Today we are taking a deep dive into one of the most heavily tested, high-pressure areas of criminal practice, advising a client at the police station. As a solicitor, your actions in the interview room can dictate the entire outcome of a trial. Today we are mastering the paced detention clock, the dangerous rules surrounding the right to silence, and the exact strategy you must use to protect your client. Let's get into it. Before you even step into an interview room, you need to know exactly how long the police can legally hold your client without charging them. If they hold them too long, the detention becomes unlawful, which can lead to evidence being excluded. This timeline is strictly governed by the Police and Criminal Evidence Act 1984, known as PACE. As a defence solicitor, it is your job to be the timekeeper. Here is the absolute maximum timeline you must memorise. At 0 hours, the clock starts. This is known in PACE as the relevant time, which is generally the exact moment the suspect arrives at the police station. The standard maximum time the police can hold someone without charging them is 24 hours. However, for indictable offences, meaning the more serious crimes, the police can extend this. An officer of the rank of superintendent or above can authorise the extension for up to 36 hours, but they cannot do this arbitrarily. They must have reasonable grounds to believe it is necessary to secure or preserve evidence, and that the investigation is being conducted diligently and expeditiously. Anything beyond 36 hours means the police lose their internal power. They must have to go to the magistrate's court for a warrant of further detention. The magistrates can extend the detention to 72 hours and then grant one final 24-hour extension up to the absolute maximum limit of 96 hours. At 96 hours, they hit the wall. They must charge the suspect or release them. While the overall clock is ticking, PACE requires strict ongoing check-ins to ensure the detention is still legally justified. A designated review officer must evaluate the detention. The first review must happen exactly 6 hours after the detention was first authorised. After the initial check, the reviews must happen every 9 hours. After each review, the officer must confirm that keeping the suspect in custody is still necessary to secure evidence. If the police miss these precise intervals, the detention can become unlawful. This is exactly the kind of procedural error you need to be hunting for when you review the custody record. Now let's talk about the interview itself. You have likely heard police caution, you do not have to say anything, but it may harm your defence if you do not mention when questioned something which you later rely on in court. Everyone has the right to remain silent, but under the Criminal Justice and Public Order Act 1994, that silence can be heavily weaponised against your client at trial. There are 3 statutory traps you must navigate. Section 34 is the most common. If your client goes no comment in the interview but later goes to court and relies on a specific fact for their defence, a fact they could have reasonably been expected to mention at the police station, the jury is allowed to draw an adverse inference. Essentially, the jury is allowed to assume the defence is a late fabrication. Section 36 and 37 are slightly different and don't require the client to rely on a fact later. Section 36 triggers if a suspect refuses to account for suspicious objects, substances or marks found on them upon arrest. Section 37 triggers if they refuse to explain that they were present at the scene of a crime at the time it was committed. Unjustified silence in these specific scenarios equals a potential adverse inference. But there are strict statutory safeguards, and this is where you earn your money. Here is the golden rule. No adverse inferences can be drawn under any of these sections unless legal advice was offered or made available to the suspect. If the police deny them the opportunity to consult a solicitor, their silence cannot be held against them. Secondly, for sections 36 and 37 to trigger, the police must issue a special warning. They must tell the suspect in ordinary language what offence is being investigated, what fact they want to account for, and clearly state a court may draw an inference if they refuse. Finally, there is the row-ball principle. If the police refuse to give you a proper, adequate disclosure and about the evidence before the interview, you can advise your client to remain silent, and you can challenge any future inferences on the basis that you couldn't properly advise them without knowing the case. So having weighed those risks, how do we advise the client to handle questions? We have 3 options. Option 1, answer the questions. This is appropriate if the client has a watertight alibi, or if the evidence is overwhelming and early admissions will help mitigate their sentence. However, it carries a massive risk of self-incrimination or a poor performance if the client is nervous. Option 2, go no comment. This is safe in the room. It forces the prosecution to prove their case without your client's help, but carries the high danger of adverse inferences later at trial. Finally, option 3, the prepared statement. This is often the ultimate strategic shield. The prepared statement is exactly what it sounds like. You draft a written document outlining your client's defence, you hand it to the police at the start of the interview, and you advise the client to answer no comment to all verbal questions. Why do we do this? It puts their defence, like self-defence or an alibi, on the record immediately. This protects against Section 34 inferences because they did mention the fact when questioned. But crucially, it totally protects the client from being ambushed or bullied or confused by an aggressive live police interrogation. It is highly recommended for vulnerable clients or complex cases. Finally, let's look at the SRA professional conduct traps that guarantee failure on the SQE if missed. First, client conflict. If you're asked to represent 2 co-defendants and they start running a cutthroat defence, meaning they are blaming each other or have incompatible stories, you have a significant risk of conflict. You must withdraw. Second, testing the evidence. If your client privately admits to you that they are guilty but insists on pleading not guilty, you can stay on the case, but your role is strictly limited to testing the prosecution's evidence and putting them to the proof. You absolutely cannot advance a positive case. This means you cannot let your client take the stand and lie, and you cannot suggest an innocent person committed the crime. Third, disclosure errors. If the prosecution makes a mistake that helps your client, such as failing to provide the court with your client's previous convictions, you cannot correct it unless a client explicitly consents it. If they refuse consent and your continued silence would actively mislead the court, you must withdraw from the case. So, to wrap up, here are some core statutes to lock into your memory. PACE Section 41, the 24-hour limit, PACE Section 42 for the Superintendent's 36-hour extension, and the Criminal Justice and Public Order Act 1994, Section 34 for general silence, and Sections 36 and 37 for objects and presence. That covers the deep dive foundations of a police station practice. Review these rules, understand the strategy, and I'll see you in the next session.